Greetings and good evening, beautiful people. Thank you so much for joining us this evening. Hope you're having a fantastic day and week. Welcome to our live weekly YouTube readings of the final report of the California Reparations Task Force right here on the CJEC YouTube channel. This is the only live reading of the California Reparations Task Force's final report on YouTube. The final report of the first in the nation California Reparations Task Force is one of, if not the, most important government reports about the Black American community since the 1960s. Equally important, it's also the foundation for current and future reparations legislation in California. The report is nearly 1,100 pages long, and we're bringing every page of it to you, chapter by chapter, every week on Thursdays at 7 p.m. Pacific Standard Time, so that you are properly educated in your advocacy for reparations in California. Today's reading of the final report is presented to you as a community service with support from the Reparations Organizing and Mobilizing Team at the Coalition for a Just and Equitable California. CJEC is California's leading grassroots organization born for reparations and reparative justice for Black American freedmen living in California. For more information on CJEC and our work helping to enact the law that created the California Reparations Task Force, California's law requiring state agencies to collect data on descendants of U.S. slavery, the Act to End Current Slavery in California State Prisons, the California Freedmen Affairs Bill, and more, visit www.cjec-official.org. Before we go any further, right now, I need you to do three things. First, connect to our YouTube channel by liking this video, hitting the bell for reminders, and subscribing to our YouTube channel. Second, get connected to us on social media by following CJEC on Instagram, TikTok, Facebook, and Twitter X at CJEC Official. Finally, get informed and involved. To do that, visit www.cjec-official.org to sign up for current and accurate California reparations news and information on our Get Involved page, and support our work by volunteering and/or donating. To donate, just click the Donate tab on the home page of our website. A special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. You can learn more about our fiscal sponsor, the California Black Women's Health Project, at www.cabwhp.org. By way of introduction, my name is Raphael H. Plunkett. I live in Southern California. I'm from Chicago, Illinois, and I'm a volunteer reparations advocate with CJEC's Reparations Organizing and Mobilizing Team. The agenda for today, Chapter 38 of the final report of the California Reparations Task Force. The title of the chapter we're reading tonight is Political Participation, Federal Statutes, and Case Law. You can follow along in the reading, download tonight's chapter, or the full final report yourself by going to our website, www.cjec-official.org/reports. Okay, we're about ready to start our reading, but before we do, I have some special thanks and announcements to make. First, as always, I'd like to thank our good friends at ETM Media Group on YouTube for their live readings of the first California Reparations Report. You can watch their readings of the first report on their channel at ETM Media Group on YouTube and on our website at www.cjec-official.org/videos. Second, for those of you who don't know, historic reparations legislation in California is here, and more is coming. SB 490 is California's first lineage-based reparations-related legislation to establish the California American Freedmen Affairs Agency. The bill was introduced by State Senator Stephen Bradford and will move forward this year. To read the bill, visit www.cjec-official.org/advocacy. Third, as mentioned, more historic reparations bills are coming. Over the next several months, more reparations bills are being written. During this 2024 legislative session, we'll see those bills introduced and start moving toward passage by majorities of both the California State Assembly and Senate. To pass reparations bills in 2024, we need 41 Assembly members and 21 senators to say yes. When those bills are passed, we need our governor to sign the bills. So, to make reparations a reality in California, the math is 41 plus 21 plus 1. That's 41 Assembly members, 21 senators, and 1 governor. 41 plus 21 plus 1 equals reparations in California. Lastly, but not least, a special thanks to CJEC's Reparations Organizing and Mobilizing Team, specifically our volunteer final report readers. And, without further ado, Chapter 38 of the California Reparations Task Force's final report. Chapter 38, Political Participation, Federal Statutes and Case Law. Part 1, Federal Statutes and Case Law. 1879. Strouder v. West Virginia, 100 U.S. 303. Summary of Facts and Issues. A West Virginia statute provided that only white male persons who were 21 years of age and citizens of the state were eligible to serve as jurors. Impact of ruling. The U.S. Supreme Court ruled that a statute denying, on the basis of race, an otherwise qualified person the right and privilege of serving as a juror impermissibly discriminated on the basis of race in violation of the 14th Amendment. 1884, Ex parte Yarbrough, 110 U.S. 651. The Ku Klux Cases. Summary of Facts and Issues. Several members of the Ku Klux Klan were charged under various federal criminal statutes, passed specifically to address expansion of the Ku Klux Klan, with conspiring to intimidate and threaten African Americans, including for the purpose of voter suppression. The defendants challenged the constitutionality of the criminal statutes, arguing that they were beyond the scope of federal authority. Impact of the ruling. The U.S. Supreme Court upheld the criminal statutes, finding that the federal government clearly had authority to, quote, protect the elections of which its existence depends, end quote. The court also held that although the 15th Amendment does not expressly grant the right to vote to African Americans, it effectively did so in states that previously denied them the right to vote. 1903, Giles v. Harris, 189 U.S. 475. Summary of Facts and Issues. The plaintiff argued that several Alabama laws related to voter registration and qualifications effectively barred African Americans from voting, albeit not explicitly. The voting laws included a, quote, grandfather clause, end quote, that automatically qualified previously registered white voters, but excluded African American voters and subjected them to stringent qualification tests. The plaintiff asserted that these laws were unconstitutional under the 14th and 15th Amendments to the United States Constitution. Impact of ruling. The U.S. Supreme Court ruled that it lacked jurisdiction and authority to grant the requested relief. Specifically, the court held that the requested relief, enrolling the plaintiff as a registered voter, would not remedy the wrong alleged, that the voting procedures were discriminatory and therefore unconstitutional. The court also held that it did not have jurisdiction to supervise the rule upon state court voting procedures. This holding essentially gave states permission to pass discriminatory voting procedures and signaled that the federal courts would not intervene. Subsequent history. Although it does not appear that Giles v. Harris has ever been explicitly overturned, the Supreme Court later issued several rulings striking down similar voting restrictions and, quote, grandfather clauses, end quote. 1915. Myers v. Anderson, 238 U.S. 368. Summary of Facts and Issues. A municipal voter registration and qualification ordinance required that a prospective voter fall into one of three categories. 1. Own property. 2. Be a naturalized citizen or the son of a naturalized citizen versus a native-born citizen. Or 3. Have been registered to vote prior to January 1st, 1865. The last requirement, commonly known as a, quote, grandfather clause, end quote, effectively barred all African Americans from voting unless they owned property or were naturalized citizens, because the cutoff date was prior to ratification of the 15th Amendment to the United States Constitution, while allowing white citizens to vote without meeting those requirements, as they or their forebears were allowed to vote prior to the 15th Amendment. Impact of ruling. The U.S. Supreme Court held that the Grandfather Clause violated the 15th Amendment because it, quote, recreated and reestablished a condition which the amendment prohibits, end quote. Although the court observed that the property and citizenship requirement appears to be constitutional, it held that they too must be struck down since they were intertwined with the unconstitutional provision. 1927. Nixon v. Herndon, 273 U.S. 536. Summary of facts and issues. A Texas statute stated that, quote, in no event shall a Negro be eligible to participate in a Democratic Party primary election held in the state of Texas, end quote. Plaintiffs filed suit arguing that it violated the 14th Amendment. Impact of ruling. The U.S. Supreme Court struck down the statute. The court first held that it had jurisdiction to hear the matter and to award damages, thus rejecting the defendant's claim that the suit raised a non-judiciable political question. The court then held that the voting restriction clearly violated the 14th Amendment since it discriminated on the basis of race. 1932. Nixon v. Condon, 286 U.S. 73. Summary of facts and issues. A Texas law allowed political parties to establish, quote, state executive committees, end quote, with the authority to set voter qualifications. The Committee for the Texas Democratic Party adopted a resolution stating that only white individuals could be qualified to vote in primary elections. The law and resolution were challenged under the 14th Amendment to the United States Constitution. Impact of ruling. The U.S. Supreme Court held that the committee in question derived its authority from the state and acted on behalf of the state. As the court stated, quote, delegates of the state's power have discharged their official functions in such a way as to discriminate invidiously between white citizens and black, end quote. Its conduct was therefore subject to the 14th Amendment, and the provision in question was held unconstitutional. 1935. Grovey v. Townsend, 295 U.S. 45. Summary of facts and issues. The Texas Democratic Party, at its convention, adopted a resolution permitting only white individuals to vote in its primary. The plaintiff, an African American, was denied the right to vote based on this resolution. He filed suit, arguing that his rights had been violated under the 14th and 15th Amendments to the United States Constitution. Impact of ruling. The U.S. Supreme Court held that the voting limitation was not the result of state action. Specifically, it ruled that, quote, the qualifications of citizens to vote at party primaries have been declared by the representatives of the party in convention assembled, and this action, upon its face, is not state action, end quote. Accordingly, the 14th and 15th Amendments did not apply to the restriction, and the dismissal of the suit was affirmed. Until it was overruled, this ruling effectively allowed states, through their political parties, to explicitly discriminate against African Americans by precluding them from participating in the selection of candidates for office. Subsequent history. In Smith v. Allwright, the U.S. Supreme Court relied upon intervening case law holding the Constitution authorized Congress to regulate primary as well as general elections. U.S. v. Classic, 1941, 313 U.S. 299, to overrule Grovey v. Townsend. 1939, Lane v. Wilson, 307 U.S. 268. Summary of facts and issues. An Oklahoma voter registration scheme set two primary voting criteria. One, automatic qualification for those who had voted in the general election of 1914. And two, a 12-day registration period for any prospective voter who had not voted in 1914. Only white individuals had voted in the 1914 election through operation or, quote, grandfather clause, end quote, that had been deemed unconstitutional in the prior case. Any individual who did not register during the 12-day window was permanently barred from voting. Impact of ruling. The United States Supreme Court struck down the registration scheme and held that the 15th Amendment, quote, nullifies sophisticated as well as simple-minded modes of discrimination, end quote. The court reasoned that the registration scheme was merely a perpetuation of the unconstitutional grandfather clause, and that the 12-day period was, quote, too cabined and confined, end quote, to undo its harms. 1942. Hill v. Texas, 316 U.S. 400. Summary of facts and issues. A Texas law set criteria to serve on a grand jury that included, among other requirements, the prior payment of a poll tax, the ownership of property, and the ability to read and write. An African American charged with a crime moved to quash the indictment on the grounds that African Americans had been systematically excluded from the grand jury, in keeping with a years-long scheme to exclude African Americans from serving on grand juries. Evidence adduced at the hearing revealed that an African American had not served on the grand jury for at least the preceding 16 years. Impact of ruling. The U.S. Supreme Court held that the petitioner had made out a prima facie case of racial discrimination in the selection of grand jurors. It reasoned that the, quote, continuous omission, end quote, of African American jurors could not have been by chance or accident, and that the record showed that the jury commissioners had, quote, made no effort to ascertain whether there were within the county members of the colored race qualified to serve as jurors, end quote. 1944. Smith v. Allwright, 321 U.S. 649. Summary of facts and issues. An African American man sued election judges in Harris County, Texas, for their refusal to give him a ballot or to permit him to cast a ballot in the primary election of July 1940 for the nomination of Democratic candidates for the United States Senate and House of Representatives, governor, and other state officers. The refusal was alleged to have been solely because of the race and color of the proposed voter. The judges argued that the Constitution did not prohibit their conduct, since political primaries were political party affairs handled by the party and not governmental officers. Impact of ruling. The U.S. Supreme Court relied on U.S. v. Classic, 313 U.S. 299, to overrule Grovey v. Townsend and hold that, quote, state delegation to a party of the power to fix the qualifications of primary elections is delegation of a state function that may make the party's action of the state, end quote. The court found that the state, quote, statutory system for the selection of party nominees for inclusion on the general election ballot makes the party which is required to follow these legislative directions an agency of the state insofar as it determines the participants in a primary election. The party takes its character as a state agency from the duties imposed upon it by state statutes, and duties do not become matters of private law because they are performed by a political party, end quote. 1960. United States v. Raines, 362 U.S. 17. Summary of facts and issues. The Civil Rights Act of 1957 guaranteed, among other rights, the right to vote regardless of race. It also empowered the U.S. Attorney General to seek an injunction against any conduct deemed to violate that right. The Attorney General used these provisions to file suit against various election officials in Terrell County, Georgia, alleging that the officials had conspired to discriminate against African Americans who sought to register to vote. The defendants challenged the statute under which the Attorney General had filed the suit. Impact of ruling. The U.S. Supreme Court held that the statute, as applied in this case, was, quote, clearly, end quote, constitutional because the defendants were engaged in state action that violated the 15th Amendment, and thus the Civil Rights Act was, quote, appropriate legislation, end quote, to enforce the 15th Amendment. Raines, accordingly, was another in the line of cases that reaffirmed federal authority to seek injunctions and criminal prosecutions against state officials who violate African Americans' civil rights. Gomillion v. Lightfoot, 364 U.S. 339. Summary of facts and issues. An Alabama redistricting law redefined boundaries of the city of Tuskegee from a square to a 28-sided figure that resulted in exclusion of nearly all African American residents. but that retained all white residents. The redistricting scheme was challenged in court on the basis that it violated the 15th Amendment. The state of Alabama argued that federal courts lacked jurisdiction to address the constitutionality of the law, claiming that states have unfettered rights to reorganize local political subdivisions. Impact of ruling. The U.S. Supreme Court rejected Alabama's arguments, holding that the federal judicial review is appropriate where, quote, state power is used as an instrument for circumventing a federally protected right, end quote. In this case, the 15th Amendment. The matter was remanded to the lower court, where the law in question was struck down. 1961. Gramillion v. National Association for the Advancement of Colored People, 366 U.S. 293. Summary of facts and issues. A set of Louisiana laws prohibited organizations from doing business in Louisiana if the organization was affiliated with any out-of-state organization whose officers or members were members of the Communist Party or related organizations. The laws also required various filings and affidavits disclosing the organization's membership, and they imposed criminal penalties for failure to do so. The National Association for the Advancement of Colored People, NAACP, challenged the laws, arguing that the provisions violated the First Amendment right to freedom of association. Impact of ruling. The U.S. Supreme Court struck down the affiliation law because, quote, it is not consonant with due process to require a person to swear to a fact that he cannot be expected to know, or, alternatively, to refrain from wholly lawful activity, end quote. The court struck down the disclosure law as violating the First Amendment. 1962, Wood v. Georgia, 370 U.S. 375. Summary of facts and issues. A Georgia grand jury was impaneled and instructed by a judge to investigate allegations of, quote, block voting, end quote, by African Americans in Bibb County, Georgia. It was specifically alleged that candidates had paid large sums of money to obtain African American votes. An elected sheriff in the county issued a press release criticizing the judge's actions and arguing that it was a, quote, deplorable example of race agitation, end quote. The sheriff was charged and convicted of contempt of court, and he appealed the conviction. The Georgia Court of Appeals largely affirmed the conviction. Impact of ruling. The U.S. Supreme Court reversed the conviction as violating the First Amendment, holding that, quote, in the absence of some showing of a substantive evil actually designed to impede the course of justice in justification of the exercise of the contempt power to silence the petitioner, his utterances are entitled to be protected, end quote. 1964, Henry v. City of Rock Hill, 376 U.S. 776. Summary of facts and issues. African American protesters assembled to peacefully protest segregation, and they failed to disperse when ordered. They were arrested and later convicted of breach of the peace. On appeal, the South Carolina Supreme Court affirmed the convictions, holding that there was, quote, ample evidence here to support the conclusion that the police acted in good faith to maintain the public space, to assure the availability of the streets for their primary purpose of usage by the public, and to maintain order in the community, end quote. Impact of ruling. The U.S. Supreme Court vacated the convictions, finding that they had been charged with an offense, quote, so generalized as to be not susceptible of exact definition, end quote. Under the court's precedent, the 14th Amendment, quote, does not permit a state to make criminal the peaceful expression of unpopular views, end quote. Civil Rights Act of 1964. Summary of law. The Act generally prohibits discrimination on the basis of race, color, religion, sex, or national origin. For example, the Act requires that voting rules be applied equally across races, and it forbids discrimination by private businesses open to the public, restaurants and hotels, and also mandates desegregation of public facilities and public schools, and prohibits discrimination in employment. Finally, the Act forbids discrimination in public, federally funded programs and also established the Equal Employment Opportunity Commission. Impact of law. The act dramatically strengthened civil rights protections in the United States. It sought to prohibit and undo harms imposed by legal segregation, and also gave the federal government power to enforce and implement the promises of Brown v. Board of Education. Title II, addressing discrimination in public accommodations, was perhaps the most immediately transformative aspect of the act, given the persistence of segregation at restaurants, motels, and other businesses. Subsequent history. The Civil Rights Act of 1964 led to several other pieces of major civil rights legislation, including the Voting Rights Act of 1965 and the Fair Housing Act of 1968. The subsequent legislation was designed to, quote, complement and reinforce, end quote, the 1964 Act, and together these and other statutes made significant progress in the struggle toward racial equality, though as reflected in this report, that progress has been uneven. 1965, Voting Rights Act of 1965. Summary of law. The Voting Rights Act of 1965 was designed to strengthen and implement the protections of the 15th Amendment. The Act in Section 2 forbids all states from implementing any voting procedure that curtails voting rights on the basis of race. Sections 4 and 5 of the Act applied to, quote, covered, end quote, jurisdictions with histories of imposing discriminatory voting procedures. Such covered jurisdictions were barred from implementing various forms of voter qualification procedures absent approval by federal authorities. Section 4 and 5 were initially set to be temporary, but were repeatedly extended by Congress. Impact of law. The Voting Rights Act, and particularly Section 5 of the Act, was, quote, one of the nation's most effective tools to eradicate racial discrimination in voting, end quote. Prior to the Act, the primary approach to combating racially discriminatory voting laws was through case-by-case litigation, which was resource-intensive and slow. Even where plaintiffs prevailed, the success was often fleeting as jurisdictions would then enact new discriminatory policies. The Act, by contrast, successfully halted voting discrimination before it could harm voters. Subsequent history. In Shelby County v. Holder, 2013, 570 U.S. 529, discussed below, the U.S. Supreme Court struck down Section 5 of the Act, essentially holding that the pre-clearance formula was no longer needed given the national progress made to limit voter discrimination. Shelby County, quote, opened the floodgates to laws restricting voting throughout the United States, end quote, including, for example, strict voter identification laws in Texas, Mississippi, and Alabama. Cox v. Louisiana, 379 U.S. 559. Summary of facts and issues. A Louisiana statute prohibited picketing or parading in front of a courthouse with the intent to obstruct court proceedings. A minister and others were charged and convicted under the statute for leading protests against racial discrimination and segregation. Subsequent history. The U.S. Supreme Court considered whether the convictions were constitutional. Although the court held that the statute was constitutional on its face, it also held that the conviction violated the rights of due process and freedom of speech because the highest police officials of the city, in the presence of the sheriff and mayor, in effect told the demonstrators that they could meet across the street from the courthouse, 101 feet from the courthouse steps. 1966, Brown v. Louisiana, 383 U.S. 131. Summary of facts and issues. 5 African Americans sought to protest segregationist policies at a public library in Louisiana that effectively required African Americans to use a bookmobile rather than the library itself. The protesters entered the library and declined to leave upon request. They were subsequently arrested and were later convicted of breach of the peace. Impact of ruling. The U.S. Supreme Court reversed the convictions, noting that the individuals did nothing more than, quote, stage a peaceful and orderly protest demonstration, end quote. Its ruling was premised on the First and 14th Amendment rights to freedom of speech, assembly, and the right to petition the government to redress grievances. The court further held that the breach of the peace statute had been used as a pretext to punish those engaging in protected and fundamental rights. 1967. Kilgarlin v. Hill, 386 U.S. 120. Summary of facts and issues. In 1965, the state of Texas passed a reapportionment plan for both the House and Senate of the Texas legislature. Appellates challenged the scheme and argued, among other assertions, that the scheme amounted to a racial gerrymander in violation of the 14th Amendment. Specifically, the appellants argued that the reapportionment plan was intended to, and had the effect of, minimizing the voting strength of African Americans in violation of the Equal Protection Clause of the 14th Amendment. Impact of ruling. The U.S. Supreme Court upheld much of the plan, but struck down one portion that diluted the voting power of voters in certain districts. The court relied on the, quote, equal population principle, end quote, set out in Reynolds v. Sims, which requires that the population per representative be substantially equal. In this case, a portion of the redistricting scheme resulted in a substantial variation among districts in population per representative, and so those provisions were struck down. Walker v. City of Birmingham, 388 U.S. 307. Summary of facts and issues. City officials in Birmingham, Alabama, obtained an injunction prohibiting certain civil rights activists from leading or participating in unpermitted street protests and marches. After the protesters deliberately violated the injunction, city officials sought to hold them in contempt of court. In response, the protesters argued that the underlying injunction was unconstitutional, but the state court declined to consider the constitutionality of the injunction. The protesters were held in contempt and sentenced to several days in jail. Impact of ruling. The U.S. Supreme Court upheld the contempt convictions. It acknowledged that the injunction might well have been unconstitutional, but ultimately held that the protesters could not first violate an injunction and then challenge its unconstitutionality. Subsequent history. In Shuttlesworth v. City of Birmingham, the U.S. Supreme Court addressed the claims of another individual associated with the same protest as in Walker. Specifically, Mr. Shuttlesworth, an African-American minister, had been convicted of violating a Birmingham ordinance prohibiting unpermitted parades and other demonstrations. Mr. Shuttlesworth attempted several times to get a permit under the ordinance, as required by the injunction, and was rejected in terms demonstrating that, quote, under no circumstances would he and his group be permitted to demonstrate in Birmingham, end quote. The court reversed the conviction, holding that the ordinance and the way it was implemented was so broad that it violated the First Amendment right to freedom of speech. 1968, Cameron v. Johnson, 390 U.S. 611. Summary of facts and issues. The U.S. Supreme Court addressed the constitutionality of Mississippi's anti-picketing law. The law was passed in response to a group of civil rights organizations that had organized pickets in front of a Mississippi courthouse, and it forbade picketing that interfered with entry into and exit from courthouses. The law was passed during an extended months-long daily protest against voter suppression, and it was used to halt the protest. The petitioners argued, in part, that the statute was vague, overbroad, and that it was passed with the discriminatory intent to halt African American protesters. Impact of ruling. The U.S. Supreme Court upheld the constitutionality of the law. It held that the law was not unduly vague nor overly broad. It also rejected the claim that the law was selectively enforced against the picketers, finding that law enforcement had a duty to enforce the law once it was passed. 1969, Gadsden County v. United States 395 U.S. 285. Summary of facts and issues. Gadsden County, North Carolina, was subject to the pre-clearance requirements of the Voting Rights Act of 1965 due to its history of using a test or other means of restricting voter registration. The county's status resulted in the suspension of a literacy test that it imposed as a qualification for voting. The county filed suit seeking to reinstate its literacy test. Impact of ruling. The U.S. Supreme Court denied the request to reinstate the literacy test. In order to reinstate the test, the county would have had to show that the test did not discriminatorily disenfranchise African Americans. The court observed that the county schools were racially segregated and that the county deprived African American students of equal educational opportunities. For example, 98% of white teachers, but only 5% of African American teachers, held regular teaching certificates, and a much higher proportion of African American students, quote, attended one room, one teacher wooden schoolhouses which contained no desks, end quote. The court thus concluded that because African American children were, quote, compelled to endure a segregated and inferior education, fewer will achieve any given degree of literacy than will their better educated white contemporaries, end quote. Subsequent history. Shelby County v. Holder struck down the pre-clearance requirement of the Voting Rights Act that prevented the use of Gaston County's literacy test. 1971, Boyle v. Landry, 401 U.S. 77. Summary of facts and issues. African American individuals and civil rights groups in Chicago filed a class action against several government officials and agencies, asserting that the officials sought to intimidate them to prevent them from exercising their First Amendment rights. The groups were specifically focused on working to end racial segregation and discrimination. They argued that several criminal statutes were being used to prosecute African Americans disproportionately, and that African Americans were being arrested without probable cause and were being held in exorbitant bail. Impact of ruling. The lower court upheld all the challenged statutes except one, which prohibited intimidating someone with the threat to commit a criminal offense. But the Supreme Court denied relief as to the intimidation statute as well, finding that the plaintiffs had failed to show any irreparable injury from actual or potential prosecutions under the statute. The Boyle ruling undercut the ability of plaintiffs to challenge the use of discriminatory criminal prosecutions, including those that are used disproportionately and purposefully against African Americans. Whitcomb v. Chavis, 403 U.S. 124. Summary of facts and issues. The state of Indiana passed various redistricting statutes, including provisions related to Marion County. After redistricting, Marion County was represented by 8 senators and 15 members of the Legislative House. The plaintiffs alleged that the redistricting in Marion County diluted the vote of African Americans, many of whom lived in a, quote, ghetto area, end quote, and that the new laws left them with, quote, almost no political force, end quote. Impact of the ruling. The United States Supreme Court upheld the Marion County redistricting scheme. It held that the plaintiffs had failed to show that their voting power had been sufficiently impacted and that there was no evidence of intentional racial discrimination. 1973, White v. Register, 412 U.S. 755. Summary of facts and issues. In 1970, the Texas House of Representatives passed redistricting measures for both the House and the Senate. The plaintiffs argued that aspects of the plan violated the Equal Protection Clause because of the variation in population per representative across districts. Specifically, certain districts had considerably more residents than others, yet were apportioned the same number of representatives. The plaintiffs also argued that 2 particular multi-member districts were being used invidiously to dilute the voting strength of African Americans and other groups. Impact of ruling. The United States Supreme Court first held that the population per representative disparities were insufficient to establish an equal protection violation. As to the vote dilution claims associated with the 2 multi-member districts, the court affirmed the lower court's finding that the redistricting scheme violated the plaintiffs' equal protection rights. The court specifically focused on Texas's long history of official racial discrimination, including its efforts to suppress the African American vote and the very few African Americans elected to the Texas legislature. It also stressed the persistence of racial discrimination in the 2 specific counties at issue. 1975, City of Richmond, Virginia v. United States, 422 U.S. 358. Summary of facts and issues. The city of Richmond, Virginia, was subject to the pre-clearance requirements of Section 5 of the Voting Rights Act of 1965, which required that Richmond obtain a judgment decreeing that any change it made in voting qualifications or prerequisites to voting did not have the purpose or effect of denying or abridging the right to vote on account of a voter's race or color. Accordingly, Richmond sought federal court approval for a plan to annex approximately 23 square miles of adjacent land. The primary question was whether the annexation had the purpose or effect of abridging the African American vote in Richmond. Plaintiffs argued that the expansion of the city limits substantially increased the proportion of white voters and decreased the proportion of African American voters, diluting their voting power. Impact of ruling. The court ruled that the annexation's impact on the African American vote was insufficient to render it unlawful. The court conceded that the African American population would decline considerably post-annexation, and that the African American community would, assuming racial bloc voting, have fewer seats on the city council. However, because the African American population would still be proportionately represented after the new council districts were drawn, the court ruled that the plan was not unlawful. The court then accepted the lower court's finding that the annexation had the purpose of diluting the African American vote, yet the court let the annexation stand subject to further proceedings to determine whether there were objectively legitimate reasons for the annexation. Subsequent history. The court in Shelby County v. Holder struck down the pre-clearance requirements of Section 5 of the Voting Rights Act that applied to Richmond's annexation. 1976, Beer v. United States, 425 U.S. 130. Summary of facts and issues. The city of New Orleans was subject to the pre-clearance requirements of Section 5 of the Voting Rights Act of 1965, and it sought authorization to implement a reapportionment of its city council districts. Under its proposed plan, African Americans would become a majority in 2 of the new districts when they had previously been the majority in only 1 district. However, the new plan would not, assuming block voting, result in African Americans being able to elect members in proportionment of their population because they were a majority of registered voters in only 1 district. Impact of ruling. The court held that the scheme was permissible since it arguably increased the voting power of African Americans, even though the African American vote was diluted relative to white voters. Subsequent history. Shelby County v. Holder struck down the pre-clearance requirements of Section 5 of the Voting Rights Act that applied to the New Orleans scheme. 1977, Connor v. Finch, 431 U.S. 407. Summary of facts and issues. Mississippi was subject to the pre-clearance requirements of Section 5 of the Voting Rights Act of 1965. In 1975, the Attorney General objected to the state's proposed reapportionment plan, and the federal district court then devised a new plan. The plaintiffs argued that the new plan violated the Equal Protection Clause's guarantee that legislative districts be of nearly equal population, so that each person's vote be given equal weight in the election of representatives. Impact of ruling. The United States Supreme Court struck down the reapportionment plan, finding that variation in population among districts was, quote, substantial, end quote, and, quote, cannot be tolerated in the absence of some compelling justification, end quote. The court rejected the proffered justification of the need to maintain historical county lines, and the new plan was struck down. Finally, the court concluded that the reapportionment plan improperly diluted the voting power of African Americans. Subsequent history. Shelby County v. Holder struck down the pre-clearance requirements of the Voting Rights Act that applied to the Mississippi scheme. 1980, City of Mobile v. Bolden, 446 U.S. 55. Summary of facts and issues. African American voters sued the city of Mobile, Alabama, which was governed by a city commission, arguing that the at-large system of municipal elections violated the 14th and 15th Amendments to the United States Constitution. Under Mobile's system, 3 city commissioners were elected at large and shared legislative, executive, and administrative powers in the municipality. The result was that African Americans, who constituted 35% of the population, could never elect their preferred candidate. Impact of ruling. The United States Supreme Court upheld the constitutionality of the at-large voting system. It rejected both the 14th and 15th Amendment claims because there had been no showing of purposeful discrimination against African Americans in maintaining the scheme. In so ruling, the court found that evidence demonstrating that 1. No African American had ever been elected to the commission, 2. The commissioners had discriminated against African Americans in municipal employment and services, 3. The state had historically and persistently discriminated against African Americans, and 4. African Americans' minority status necessarily resulted in dilution of power under the at-large system was irrelevant. Subsequent history. In response to City of Mobile v. Bolden, Congress amended the Voting Rights Act to make clear that a voting scheme could be deemed unlawful if shown to have a discriminatory impact, even without showing discriminatory intent. 2009, Northwest Austin Municipal Utility District No. 1 v. Holder, 557 U.S. 193. Summary of facts and issues. A small utility district in Texas sought to be released from the pre-clearance requirements associated with the Voting Rights Act of 1965 and argued that Section 5 was unconstitutional. There was no evidence that the district itself had previously discriminated in its voting systems, but it was subject to Section 5 because it was a political subdivision in Texas, which was subject to Section 5. Impact of ruling. The United States Supreme Court ruled that the district could qualify to, quote, bail out, end quote, of the pre-clearance requirements, even though it is not a state. In so ruling, the court avoided addressing the larger question of Section 5's constitutionality. 2013, Shelby County v. Holder, 570 U.S. 529. Summary of facts and issues. Shelby County, Alabama was subject to the pre-clearance requirements of Sections 4 and 5 of the Voting Rights Act of 1965. Sections 4 and 5 of the Act applied to, quote, covered, end quote, jurisdictions with histories of imposing discriminatory voting procedures. Such covered jurisdictions were barred from implementing various forms of voter qualification procedures absent approval by federal authorities. Sections 4 and 5 were initially set to be temporary, but were repeatedly extended by Congress. After the Attorney General objected to certain proposed voting changes, the county filed suit and challenged the constitutionality of a pre-clearance requirements. Impact of ruling. The United States Supreme Court struck down Section 5 of the Act, essentially holding that the pre-clearance formula was no longer needed given what the court found to have been national progress made to limit voting discrimination. The court stressed the, quote, substantial, end quote, federalism concerns associated with Section 5, particularly that different criteria apply to different states under the Act. The Shelby ruling, quote, opened the floodgates to laws redistricting voting throughout the United States, end quote, including, for example, subsequently enacted strict voter identification laws in Texas, Mississippi, and Alabama. Section 2. State Statutes and Case Law. 1849. California Constitution of 1849, Article 2, Section 1. Summary of facts and issues. The first California Constitution severely limited the right to vote. Quote, every white male citizen of the United States and every white male citizen of Mexico who shall have elected to become a citizen of the United States under the Treaty of Peace exchanged and ratified in Querétaro on the 30th day of May, 1848, of the age of 21 years, who shall have been a resident of the state 6 months next preceding the election, and the county or district in which he claims his vote 30 days, shall be entitled to vote at all elections which are now or hereafter may be authorized by law. provided that nothing herein contained shall be construed to prevent the legislature, by a 2/3 concurrent vote, from admitting to the right of suffrage Indians or the descendants of Indians in such special cases as such a proportion of the legislative body may deem just and proper. Subsequent history. The section was amended in 1879 and then again from 1970 to 1974. The 1879 version removed, quote, white, end quote, but also included that, quote, no native of China, no idiot, insane person, or person convicted of any infamous crime, and no person hereafter convicted of the embezzlement or misappropriation of public money shall ever exercise the privileges of an elector in this state, end quote. The current Constitution reads, quote, a United States citizen 18 years of age and resident in this state may vote. An elector disqualified from voting while serving a state or federal prison term shall have their right to vote restored upon completion of their prison term, end quote. 1971, Calderon v. City of Los Angeles, 251. Summary of facts and issues. Residents of the City of Los Angeles sued based on the city charter's requirement to redistrict its council districts based on the number of registered voters. Impact of ruling. The court ruled that apportionment of a, quote, one voter, one vote, end quote, basis rather than on, quote, one person, one vote, end quote, basis denies equal protection where apportionment on such basis resulted in the largest district having nearly 70% more people than the smallest. 2001. Elections Code Section 14025, California Voting Rights Act of 2001. Summary of provisions. The California Voting Rights Act addresses vote dilution and voter discrimination by providing a private right of action and other remedies for the use of any at-large voting systems and any other voting systems in which racially polarized voting occurs. Subsequent history. In Yumori Kaku v. City of Santa Clara, the California Court of Appeal found that the applicability of the act did not unlawfully impinge on a city's plenary authority to control the manner and method of electing its officers. In 2019, the California legislature enacted Assembly Bill No. 849, the Fair and Inclusive Redistricting for Municipalities and Political Subdivisions, Fair Maps Act, that requires each local jurisdiction to adopt new district boundaries after each federal decennial census, specifies redistricting criteria and deadlines for the adoption of new boundaries by the governing body, specifies hearing procedures that would allow the public to provide input on the placement of boundaries and on proposed boundary maps, and requires the governing body to take specified steps to encourage the residents of the local jurisdiction to participate in the redistricting process. And that will conclude tonight's reading of Chapter 38 of the California Reparations Task Force's final report. Before you go, if you haven't already done so, don't forget to like this video, hit the bell for reminders, subscribe to our new YouTube channel. When you go, don't forget to get connected. Follow CJEC on all social media, Instagram, TikTok, Facebook, and Twitter X at CJEC Official. Get informed. Visit www.cjec-official.org and sign up for current and accurate California reparations news and information on our Get Involved page. Get involved. Support our work by volunteering and/or donating. To donate, just click the Donate tab on the home page of our website. A special thanks to our amazing fiscal sponsor, the California Black Women's Health Project. Thank you all so much for your time. I appreciate you all. We are closer to reparations than we've ever been in California. Have a great night.